Hi, I'm Judith Proctor and I'm the Chief Officer for the Edinburgh Integration Joint Board, and I'm also the Chair of the National Chief Officers Group. And I'm here today to try and answer some questions about power of attorney and to talk a little bit about why it's such an important thing to do. It's a really good question, and I think it's never too early to start a conversation about power of attorney. I think it's also important not just thinking about professionals who are meeting with people in the course of their job, but for all of us to be thinking about that with our friends and our families and our loved ones. I think it can be a very, very simple question. Have you thought about power of attorney? And I think for professionals and for us all, it probably does no harm at all to find out a little bit more so that you're comfortable having that conversation, that you know what it is, you know where to turn to, and you know the sort of resources that you can point people to so that they can give it proper thought. What should you say to somebody when they're asking about power of attorney? Well, I think there's a few things to say. One, it's a really simple thing to do. Two, it's really, really important. And I think it's helpful just to ask that question. Have you thought about what you would do if you weren't actually able to make decisions for yourself? Have you thought about who you might want to do that? And have you thought about what those wishes might be in those circumstances? So I think it's maybe helpful to start with the have you thought about question. So most people would use a solicitor to draw up a power of attorney, but you can draw up your own wishes for yourself, and that's maybe a good place to start, just to ask that question. Who would you like to support you? Who would you want your attorney to be? And what would your wishes be? There's also lots of information available online. mypowerofattorney.org.uk is a good place to start because that really focuses exclusively on power of attorney. Also, the Office of the Welfare Guardian will give you really good information and advice, and the Law Society of Scotland. I think it's really important to say that whilst most people will use a solicitor, it's a really, really easy process to get started and a really, really quick one. And I think it's just important to know it's not a complicated process at all once you start. Anybody with legal capacity who's over the age of 18 can be given power of attorney. What's really important in that is that it's somebody that you know and you trust, and that you've had that conversation with them so they know what your wishes are and that they are happy to undertake your wishes as your attorney. Power of attorney is granted by you when you've got the mental capacity to be able to do that. So it's a choice that you make, knowing that at some point in the future you might be incapacitated and not be able to make those decisions. Guardianship is different. Guardianship is granted when somebody doesn't have legal capacity. And I think what's really important there is that if you get the opportunity to grant power of attorney whilst you have capacity and can make your wishes known, those wishes will be able to be enacted quickly. Welfare guardianship can take some time. It's a court process and it has to be granted by the courts, and that can stop you being able to have your wishes met. An example of this might be where somebody has been hospitalised as a result of a stroke or because they have become incapacitated through a dementia. We see more and more people getting delayed in their discharge from hospital whilst they and their family have to wait for a decision to be made in relation to welfare guardianship. This has to go through a court process, and until that process has been undertaken, nobody can be legally moved from that hospital to a care home of their choice or back home. So it can delay those processes and be really, really difficult for families who are already dealing with a really difficult situation. So where power of attorney was in place, those decisions would be able to be enacted more quickly. So if you don't have power of attorney and require to get welfare guardianship, it does make a difference. When you have a power of attorney, you appoint your attorney, you appoint the person that acts for you. And if you don't have power of attorney, you've got no say in who the court appoints to be acting on your behalf. You don't have any say in the scope of what's actually given to the welfare guardianship either, whereas with power of attorney, you can set out the scope for how you want your wishes to be enacted. It might also be more costly for your family to go through that process, and it's likely that that'll happen a very, very difficult time for people and families. So that can be difficult too. And you also might be limited in some of the things that you're able to do, such as selling assets, should you need to do that to support your care. We really strive in health and social care to be person-centred in the care and support that we provide to people, to work with people on what they wish for their future and how they want to live their lives. Power of attorney really supports us in that. So if you were to become incapacitated and not be able to make decisions, it helps your carers, it helps your healthcare workers to understand what you wanted in those circumstances and to the best of their ability to be able to deliver that with you.